Hello, my name is Dora Brkić.
My name is Dora Prpić.
My name is Husnjak.
We are Team Croatia. The European Union has implemented multiple initiatives aimed at achieving one of its ultimate goals, the European single market, a territory without any internal borders or other regulatory obstacles to the free movement of goods and services. Due to the European single market, the number of cross-border consumer transactions in the European Union is growing at a rapid pace. Unfortunately, cross-border transactions do not always end with the outcome desired by both parties, and the consumer faces the alternatives to pursue the case in court or to give up the claim. Most European Union member states have introduced some form of simplified and cheaper civil procedures designed for the pursuit of small claims, but those procedures weren't well adapted for cross-border disputes. Therefore, the European Union started a process of harmonization of European civil procedure, and the Regulation 861 of 2007, adopted on 11 July 2007, established a European small claims procedure. The European small claims procedure became applicable on the 1st of January 2009 in all member states except Denmark. It was evaluated in 2013, and in the same year, the European Commission published a report and adopted a proposal amending of the regulation. The European Small Claims Procedure was amended by adopting the regulation number 2015-2421, which became effective on the 14th of July 2017. According to the preamble of the regulation, the objective of such a procedure should be to facilitate access to justice and to simplify and speed up litigation concerning small claims in cross-border cases. In order to get a more accurate picture in terms of actual use of the European Small Claims Procedure and related experience in the Republic of Croatia, we decided to conduct a survey with the support of the Croatian Bar Association, in which 60 lawyers were interviewed. As for the first question, the interviewed were asked if they are familiar with the regulation number 861 of 2007, and from the results, 60% of the interviewed lawyers are familiar with the regulation, while 40% aren't. Our second question was directed to find out if they have ever applied the regulation number 861 of 2007, and as for the result, 85% of the interviewed lawyers have never applied the regulation. In the second part of the survey, we wanted to know how do lawyers evaluate the experience of applying the regulation, and according to the results, 13.3% of the interviewed lawyers have positive experience, while 1.6% have negative experience. Regarding the efficiency of the procedure introduced by the regulation, 6.6% of the interviewed claimed that the procedure introduced is efficient, while 8.3% claimed that the procedure isn't efficient. In our last question, we asked the interviewed if they think that the procedure introduced by the regulation is more cost-effective for the parties in terms of cost of proceedings, like payment of court fees, translations of documents, etc., compared to ordinary proceedings under national law. And according to the results, 10% of the interviewed claimed that the procedure introduced by the regulation is more cost-effective compared to ordinary proceedings, while 5% of the interviewed claimed that is not.
Considering the results of the survey cited by colleague Brkić, it became completely clear to us that there is a lack of knowledge about the existence of the regulation in question in the Republic of Croatia. First of all, we should emphasize that the websites of the competent courts in the Republic of Croatia do not contain sufficient information on the European Small Claims Procedure, and we believe that it will certainly be necessary for the competent national courts to have such information on their websites as well as the standard forms. According to the regulation, European small claims procedure is essentially a written procedure in which all submissions, such as claim, the response, counterclaim, etc., and relevant supporting documents should be submitted in the language of the court. Standard forms are available on the European Union's official website, and it is possible to translate the completed form into the language of another member state on the same website. Although the existence of the e-forms greatly facilitates the procedure, we believe that it requires some improvements. The first problem we encountered was the online translation of the completed form did not translate open-ended questions, which is problematic for a potential claimant. If the possibilities of translating open-ended questions were opened, we believe that this would greatly facilitate the procedure. Under the regulation, the claimant initiates the European small claims procedure by filing the standard Form A directly with the competent court by post or other means of communication, which are acceptable, of course, to the member state. Given the existence of the e-forms, we believe that for the future, in favor of both speeding up the procedure and greater application of the European small claims procedure in the EU, it would be very useful to enable the delivery of standard forms and thus initiate the procedure electronically via the same pages. In any case, it would certainly be necessary for the competent courts of the member states to have electronic communication in place. Although such a digitalization of the process, both of member states and EU level, would be a significant undertaking, we believe it would make a significant contribution to the European small claims procedure in the long run. If such digitalization would ever come to life, it would be necessary to enable the possibility of uploading written evidence in such e-forms. That, of course, because the delivery of e-forms electronically would not make sense if written evidence had to be submitted by post, fax, etc. However, before the existence of such digitalization of the European small claims procedure, further clarification in this matter is not needed.
In relation with the last question of our survey, we noticed the costs and expenses are another interesting part of the European small claims procedure. There is a general provision in the regulation which states that the unsuccessful party should bear the costs of the proceeding, and that means that the so-called loser pays principle is adopted. But if the costs of the procedure are unjustified, the party should be aware that that kind of costs will not be awarded. The costs and expenses which can arise in the procedure are costs of court fees, which are obligatory for party to pay, costs of translation of documents if they are in a language the defendant does not understand, cost of hiring a lawyer if party had one, which is not obligatory, cost of a hearing when it's being held, which may include, for example, cost of experts and witnesses. In general, the European small claims procedure should be a low-cost procedure, but we think the expenses of it can still add up, so it becomes financially tough for the parties. In our opinion, there is a problem about paying court fees. They are calculated differently in every EU member state, so the court fees that are relatively high may discourage the party from using the European small claims procedure. Also, even though there is information on the official EU website on the amount of the court fees in every member state, some data for most member states are missing. Value of the claim under regulation is presented in euros, but on the official EU website, the amount of court fees is stated in currency depending on member state. For example, for the Republic of Croatia, that is Croatian kuna and not euro. So that is also one of the problems for the party, because it's difficult to know exactly how much the court fee will be. For that to be avoided, and in other words, to increase the number of European small claims procedures, we think that the amount of obligatory court fees should be equal in the all EU member states, for example, less than 5% of claim value. With that being said, all EU member states should have a tariff with costs written and calculated especially for the European small claims procedure, and the paying of them should be available only in money. To make paying of court fees and other expenses in the procedure easier for the parties, it should be possible to pay them online through mobile applications, which could automatically calculate court fee taking the value of the claim into the consideration, and all that while filling out e-forms. In that kind of online paying through mobile applications, bank account numbers of municipal and commerce courts in the European Union should be available, so the party, wherever it is in Europe, knows exactly where, how, in which currency and how much it needs to pay in order to pursue legal action using regulation. In our opinion, that would certainly strengthen the European small claims procedure and provide certainty and equality for the parties.